Okay, good evening, everybody. Welcome once again to the Yenka show, which is Let's Talk Law. We've not had this show for some time now, and so we apologize to our listeners that we've had some kind of break. And whilst we've had this break, we have been showing some of our previous broadcasts as well. So those of you that have tuned in, I'm sure you've benefited from some of the previous videos which we've made available on Facebook. Now, obviously, we're streaming from a different platform now, but it's still being broadcast on the Jacqua Radio and live on Facebook as well via the Jacqua Health Foundation Facebook page. In addition to that, we have got a YouTube channel now, which is the Jacqua Media, and we're streaming live on YouTube as well. So this program is coming to you live on Facebook and also on Jacqua Radio and also on the Jacqua Media YouTube channel. Just as we've been doing it since we started the show, the sole purpose of this program is to bring you legal updates, information, education, all with the objective of empowering you so you can make informed decisions. As we said before, ignorance of the law is never an excuse. And so it's important that as a community, we educate ourselves properly and also have a good understanding of most aspects of the law that we encounter in our day-to-day lives. Now, as a show, we do have a broad range of panel of expertise with different legal backgrounds who have been assisting by bringing you our program. So we have treated in the past criminal law, we have treated employment and immigration, and today we're going to be doing employment law, and we're going to be specifically talking about employment contract variation. Now, just bear with me a minute before I introduce my guest, just to share our page on Facebook. And also, if you are watching us, I will encourage you to share our broadcast as well, so your friends and family can also benefit from the program. So I am going to do that now, and then I'll introduce my guest. So just bear with us for a minute so we can share it to the various groups, and then they can all join us. So just bear with me for a sec. I think I've also had feedback from our technician that I think our radio feed, there's some technical problems with our radio feed. So bear with me whilst we try to sort this out now, and I apologize for that. And then we will be live soon. Share it to the various groups. Okay, so I can see that, yeah, we're live on Facebook. So yeah, if you just tuned in to watch us, we just trying to share with our various groups as well, so they can all tune in and listen to this program today. So just bear with me whilst we do that now, and then we will continue with the program very shortly. Okay, all right. So that's been done right now. So if you just tuned in, you are listening to the Mmra show, and thank you for tuning in today and for listening to us today as well. So today we will be dealing with employment law, and the specific topic that we are going to be treating is employment contract variation. How do you vary your employment contract, its implications, and all that. With me today is our employment law and HR consultant, a lawyer in her own right, who has vast amount of experience in this area, and her name is lawyer Ernestina Efrie, and she's the one that is going to lead out in this presentation. Now, if you've not listened to us before, my name is lawyer Kofi J. I'm the host for this program, and I'm a solicitor in England and Wales. I have experiences in terms of practice experience in immigration crime, but currently I specialize in property law. So anything to do with property conveyance, and that's my current specialty. But I do have practice experience in immigration and crime as well. So I will be hosting the show today, and Ernestina will be our guest, leading us out in a presentation. Now, before we delve into the presentation for today, I thought it would be a good thing. It would be a good thing to bring some important information to our listeners. So we've in the area of immigration, and it's just a reminder that if you are an EU national or a dependent of an EU national, obviously, as you're aware, the UK left the EU in 2019, in March 2019. And since that, we've been in a transition period, and that transition period is coming to an end 31st of December 2020. As of now, the UK have not managed to reach an agreement with the EU, so things are still up in the air as to how things are going to pan out. But there are some very important deadlines coming up in the area of immigration that we want our listeners to be aware of. So the 31st of December is the end of the transition period. And so people that are processing application to bring their family members from outside of the European Economic Area to qualify under the new EU settlement scheme, they have to ensure that they are in this country before the end of the transition period. So that's something that people need to be aware of. Now, for our EU nationals and their dependents who are already in the UK, you have till the 30th of June 2021 to make your application under the new settlement scheme. So we do get a lot of questions on this, and so I just thought I'll reiterate the various deadlines that we have for this, so our listeners can be aware and take necessary actions to ensure that they meet this deadline. But we'll not be talking about immigration today. Today, what we'll be talking about is employment law and employment contract variation. That's what we're dealing with. And with me is our special guest, lawyer Ernestina Efrie, who will be leading out in that. And so we will delve straight into that and deal with this. So Ernestina, welcome to the show. It's been a while since we came on the show.
Thank you, Kofi. That was a very good break.
Yes. Okay. All right. So that's my welcome to the show, and also thank you for coming on today again to talk about this important topic. So I will hand over to you to lead us out in the presentation for today.
Okay, thank you. So I'll try and share my screen to begin with your new system. I hope it works.
Oh yeah. Okay. So I
hope you can see the screen.
Yes.
Good. But thank you everyone for joining in today again. Yeah. As Kofi has rightly said, we are discussing variation to employment contract or changes to contracts of employment. Before I go on to discuss this, I just want to reiterate the disclaimer that the information we're giving here is only for educational purposes. If you have a legal question or if you have any legal issue, please speak to a lawyer. Take legal advice because the facts of each case is different and therefore the results will be different. So don't take all that you hear from us here to make your decisions. Thank you. So today we are looking at changes to employment contracts, and we will be looking at what are the terms and conditions of our employment contract. We'll be looking at the common variations or common changes that the employer make to our contracts. Then we will look at variation clauses in our contract. So changes, clauses in our contract that give the employer power to change the contract terms whenever they want and however they want. And then we also look at agreeing or objecting to any change to your contract and the remedies. So what are the terms and conditions of our contract? Please be reminded that we are talking about employment contracts. So only employment contracts are we dealing with this evening. So in every, sorry, in every employment contract, you or in the workplace as an employee, you have three contractual or you have three different terms and conditions to your contract. So there's the contractual terms, there's the statutory terms, and there's custom and practice. So the contractual terms are the terms that are in your contract. The statutory terms are the rights that you get from law or from regulation. So the contractual terms most of the time include the statutory terms, but sometimes they are enhanced or they are more generous than the statutory terms. And then custom and practice are rules of a trade. So if in a particular setting or business, this is how things are done, these are the shifts that people do, then that is also part of your contract. So today we will be dwelling more, or we'll be discussing the contractual terms. So the terms that are in your contract of employment, that is what we're going to discuss today. So the contractual terms, what are they? Where can you find them? So you should have a contract of employment. Every employee, worker, 0-hour contract, agency worker, whatever you are or whoever you are, whatever employment status you have, since last year, April 2020, there was a law that every employer should give the employees the basic terms of their contract of employment. So if you haven't been given a contract of employment, go to your employer and ask for a contract of employment because you are have the right to one. So what will be on this contract of employment? There are a lot of things that can be on. I haven't listed all of them, but the basic ones or the common ones that you will see are your place of work, the hours you will be working, holiday and holiday pay, sick pay, overtime, redundancy will be on it, disciplinary and grievance procedure will be on it, a lot of things. Everything that will happen in the workplace is in your contract of employment. If it's not in the contract of employment, the contract will direct you to where you can find it, and usually it's in the employee handbook. So the employee handbook is part of your contract of employment. So what are the common variation or what are the common changes that employers make to our contracts? Examples are reducing your working hours. So your supervisor or your manager will come to you and say, well, from next week, we are reducing your hours from 5 hours to 3 hours, or we are reducing from 8 to 5 hours, or we're reducing you from full-time to part-time, or we are changing the days you work. So that is a variation in your contract. If they are cutting the basic pay or they're reducing the bonus or overtime rate or how much you get paid when you go on holiday, that is also a variation or a change to the terms and conditions of your contract. Your employer can also reduce the amount of sick pay you get when you are off sick. That is also a variation or change to the contract. If they are refusing to give you a pay rise, which is catered for in your contract, then that is a change in your contract, because your contract said at this time every year you will get a pay rise. So if they're taking that right away, then that is the change to your contract. Your employer can also move you from one site to another, and that is also a variation or a change in your contract. So are all contract changes legal? I've termed this slide illegal variation. So even though the employer can vary your contract or change your contract, there are some variations that are not allowed legally. So when I was explaining the terms and conditions, I stated the second one was statutory rights. Any variation that takes away your statutory rights is illegal. So I've put some examples here. The holidays you are entitled to and the pay you should get is catered for by law. What redundancy pay you should get is catered for by law. What notice pay you should be given if you are leaving the job or if you're being dismissed or you're resigning is catered for by the law. So if your employer is changing these rights so that they take you beyond what the law has provided for you, then that is illegal. So an example would be if you are full-time, you are entitled to 28 days holiday. If your employer comes to work one day and tell you, well, I'm changing your holiday entitlement to 25 or 20 days a week, that is illegal. That is unlawful. So you can challenge that. So what are variation clauses? Variation clauses are clauses that employers put in your contract so that they can change your contract at will. Basically, that's what it means. So for an employer to change your contract, you have to agree. As in every contract, you have to agree to the change. But to avoid that consultation and you saying, no, I don't agree, employers put clauses in the contract. And because that clause is in your contract and you have signed that contract, it means you have agreed to every change that is in the contract in advance. So when they are making that change, because you've agreed, they just inform you that we have made these changes, and you cannot most of the time challenge it because you've already agreed to that change when you started the job or when you signed the contract. Some examples of these variations are that you may be required to work at various sites when required. This is a location clause, and what it means is that the employer can ask you to go and work in any other site that they have, and when they ask you, you have to go. Although it has to be reasonable, most of the time when there's a relocation clause, you can challenge it greatly. Another example would be overtime rates, where they say normal hours is 40, but you may be required to work overtime at weekends, which will be paid at this time and half, or which will be paid time and quarter, or at this rate. That is a clause in your contract. So if one weekend they say you have to do overtime, you cannot say, well, sorry, I won't do it, because you've already agreed to do it when you started the job.
Okay.
Another one will be your normal working hours is 40 a week, but this might increase if the circumstance calls for it. So they've given you the 40 hours, but what they are saying is you might be working more than that if we need you to, and you've signed it. So that is part of the contract, and they can just use it. So agreeing to or objecting to the change. Do you have to agree to a change, or do you have to object it? Whether you agree to a change or object it depends on a lot of things. So as I said previously, you must accept the change for it to be valid, unless there's a variation clause in your contract. So if there is a variation clause in your contract, the employer does not need your agreement because you've agreed to that change when you sign the contract. But if there is no variation clause in your contract, then the employer needs to consult you and you have to agree before the change is valid. If your employer tells you he's changing your contract and you don't object to it and you keep on working, you are deemed to have accepted that change. So let's say you don't have any variation clause in your contract. Your employer told you that they're going to change your hours from 8 to 5 hours a day. You didn't say anything. You kept on working 5 hours. That means you have agreed to that change and your contract hours are now 5 hours instead of the 8 hours. If you object to the change, you have to tell your employer that, I'm sorry, I do not agree to this change. It is not in my contract, so I don't want to do it. Once you've done that, you've objected to it. So even if you are working, you cannot be deemed to have accepted it because you have objected to it and you're waiting for them to do what they want to do next. Unfortunately, you cannot work under that protest indefinitely. So if you have told your employer that you don't agree to the change, so you object to the change and you are working, you have to think of what you will do next. What is your next step? If you are working 1 week, 2 weeks, then you're doing it every day, then it will be a time that it will mean you have accepted it. So if you don't agree to it, you have objected it and you are working, then you are either going to resign and claim constructive dismissal, or you continue working. So if you're objecting it, then you should give yourself like 2 weeks. I'm going to do this for 2 weeks. If they don't say anything, then I'm leaving. Or if they don't change their mind, then I will badge. I will just accept it and take it. What are the possible actions you can take when your employer decides to change your contract? I've put the easy one first. Accept the change. that is the simple and the easier one. And that's why negotiate the change. The third, you can raise a grievance and you can take legal action. We will look at these in turns. So legal action should be the last resort because there aren't many remedies for that. So you should try all the first three, and if it doesn't work, and if you've got a very good case after speaking to a lawyer, maybe you should think of legal action. So accepting the change. If the change is one that preserves your statutory rights, then I will advise you to accept it. So an example will be where your employer gives you 35 days holiday, and for some reason they've come back and say, we are sorry, we will have to change that. So we are reducing it to the statutory minimum, which is 28 days. You have lost some days, but you have not lost your statutory rights. So it will be advisable to accept this change or maybe negotiate it some way rather than challenge it. Because if you're going to go to tribunal, a tribunal is going to ask you, what have you lost? Statutory, what are you entitled to? 28. Has your employer given you 28? Yes. So the other one that you had was out of the employer's generosity. So if they say they don't want to give it to you anymore, there isn't much you can do. There are extreme cases where you can fight it, but my advice would be if you've got your statutory rights preserved, then it will be advisable to accept the change. Why am I saying that? Because there are no equal bargaining powers in employment relationship. So if you are entering into a contract with someone, or if you're going to buy something from someone, there's equal bargaining power. You have got the money to buy from them, and they have got the item they are selling. You can decide not to buy it, and they can not to sell it to you. That is not quite what happens in employment law because you need a job. So the employer always have a stronger bargaining power. They can dismiss you. They can say, well, we don't want you in the job anymore. So if you are going to object to a change, you have to think about it carefully, because there's the risk of you losing your job. The employer can say, well, if you don't want to accept the change, then you are dismissed. One tricky loophole that employers use, and I have advised a lot of employers to use it because it is the law and they can use it, is to just terminate your contract and give you another contract. So if your contract says you are entitled to, let me use my hours example, 8 hours, and the employer is saying, I've got some structural restructuring going on, and unfortunately, we cannot give you 8 hours anymore. We're giving you 5 hours. And you say, no, I don't want it. They will terminate the contract that says they are giving you 8 hours, and then they will give you a new contract that says they are giving you 5 hours. What you can do is to refuse not to sign the new contract. So if you refuse not to sign the new contract, you have been dismissed. And therefore, what you'll be looking at is unfair dismissal claim or breach of contract claim. If you're going to go for unfair dismissal claim, there are a lot of limbs that you need to. Are you an employee? Have you worked for 2 years? And all that. If you qualify for all of that and you are able to bring a claim at the tribunal is going to ask you, what outcome do you want? Compensation, reinstatement, or re-engagement. Compensation is to give you money for what you have lost. What have you lost? You lost your job, you were giving back your job. The minimum the tribunal might give you is the difference between, which is the 3 hours. But that will be enough for a whole year. It will be for the period that you were dismissed. So if you were dismissed for 1 month before the case got to tribunal, you will get 3 hours a week paid for. That is all that you will get from the tribunal, because the contract, they gave you a new contract. And when your contract is terminated and there hasn't been 1 full week before a new contract was given to you, then your continuous employment has not ended. So because they terminated and gave you another one, it was continuous employment. They never ended your continuous employment. So you haven't lost the right to bring unfair dismissal claim. So you don't get anything for that. You don't get compensation because it's only reduction in your the hours you work. And because you haven't worked those hours, you're not entitled to any money for those hours. That 1 week break that I talk about is not like Monday to Monday. It has to be, it's an Adventist, a typical Adventist 1 week. It has to be from Sunday to Saturday. So if you were dismissed on Monday, your 1 week will start from the following Sunday to another Saturday. So it's almost 2 weeks before you get that 1 week to get that break. So it's very difficult to get that break to bring a claim to get more money. So it's sometimes reasonable to just accept the change if it's not too severe, if it's not discriminatory, if it's not because they are just picking on you, but if there's a genuine reason for that change and your statutory rights have been preserved, then most of the time it's good to just accept the change and move on. One reason that I said you should.
Yeah, there's a lot there's a lot of questions coming through now.
Yeah.
Some of them relate to what you've already said and the point that you just made. So maybe I think it'd be a good time to address them.
Okay.
Before we move on. So somebody's saying that is this a way that employers use to get rid of people that they don't want in their employment by varying the contract? And obviously, as you just said, if they've got the option to just terminate your existing contract, give you a new one. Is this something that employers, is this just a strategy for employers who they don't want somebody? Or even what I'll add to it is, obviously, if employer wants to change, it looks like this is a lot of bargaining power to the employer to just do this. And in terms of recourse for the employee, it looks like there's very little point to challenging this. How do you explain and clarify that?
Okay, so I wouldn't say it is the way employers get rid of people they don't want. Because if they try to change it and you agree to it, they will not dismiss you. So that won't be an effective way to get rid of you because they don't want you. But it's one way of dismissing people and it's risky for them. That's why they will dismiss you and give you a new contract. So in this situation, they will not just dismiss you and not do anything about it.
Okay.
Yes. So it's the way what they use to change the contract. It's not really an effective way of dismissing employees because it's a bit risky for them as well.
Yeah. Okay. All right. That's fine. I think there was a question about compensation for the lost entitlement, but I think you explained that. And so if your contract is varied and you've lost something, albeit you've not lost your statutory rights, what compensation, if any, are you entitled to?
So as I said, there's the breach of contract bit. So they've breached the contract by trying to change it. So you will have to, where there's a breach, you have to provide what you've lost as a result of the breach, and that will be the compensation.
Okay.
So if they reduce your hours from 8 hours to 5 hours, and you didn't want the 5 hours, your actual loss would have been the 3 hours.
Yes.
So that is what you will get. That is the compensation you will get. And that 3 hours, they are not going to pay you for a year or any time. They will pay for the time that from the time you were dismissed to the time the case is going to the tribunal. Most of the time at tribunal cases, they look at how long it will take you to find another job and all that. But trust me, it will be based on that loss. Compensation is to put you in a position you were in before the breach.
Yeah, obviously, as a solicitor, I get that point, but from a lay person's point of view, that seems very, very unfair because obviously the entitlement was that he had these extra hours for the duration of the contract, especially if it was a permanent contract.
Yes.
Then that was the entitlement. So
yes.
It looks like you've been shortchanged in a way, and your entitlement or compensation as well has just been reduced.
Yeah, to when the breach occurred.
Yeah. So obviously, from a layperson's perspective, that is not putting him in a position he would have been in. So how do you explain that?
Well, that is the position you would have been in because the employer is saying, I haven't got 8 hours, I've got only 5 hours.
Yes.
Okay. So I will pay you 5 hours. Unfortunately, these things happen and there isn't much you can do about it. So that is what they are saying. This is their business case. They cannot pay you for 8 hours, but they are not dismissing you. They are reducing your hours to 5 hours. So what you have lost is the 3 hours. Nobody knows what will happen tomorrow. So the employment tribunal cannot ban the employers or tie the employer's hand to keep paying you that 3 hours until when the contract would have ended or when the contract will end. They are only looking at the period between the breach and the case coming to the tribunal. So that is where you have lost.
So the more or less, in effect, if there's an economic reason for that reduction, then that is an acceptable reason to vary the contract from an employer's perspective. Obviously, I'm playing the devil's advocate here by being on the side of the employee. So by trying to bring these issues up and obviously allowing people to enabling people to understand what some of the considerations are going to be. All right, thanks for clarifying that. I think the last question that came in is a good question as well, is that what form, so the person is asking, what form should the change be communicated? So if there is a change, as you did mention, if your contract of employment allows for the variation to take place, then they just inform you this is a change we are making. What form should it change? Because will a verbal, if it's just communicating to you verbally, suffice, or it has to be in writing or email, or what? Does it have to be any form that it needs to take?
Okay, so if you've got that variation in your contract, it's a letter. They have to tell you in writing, and they have to give you notice, especially if it's about pay. Sometimes if they are changing the pay frequency, I've got a lot of queries about that. So when they pay you on a weekly basis and they are changing to a monthly basis, they have to give you a whole month notice, because you would need to rearrange your direct debit and other things that are coming from the budget by that frequency. So they have to communicate to you in writing, and they have to give you reasonable notice. And as I said, it depends on what the change is.
Okay.
So they have to give you reasonable notice so you can make arrangements for that change. If it is not in your contract, if there's no variation in your contract that is permitting them to make that changes, then there have to be a consultation meeting with you. So they have to call you into a meeting and tell you why they need to make those changes.
Yes.
And then you can ask them questions and suggest ways of resolving without making the changes. And if nothing happens, then the change will go ahead, and then they'll give you the notice as well.
Okay, all right, brilliant. If you just tuned in, you are watching the Yenka Mmra show, Let's Talk Law. And today we're discussing employment contract variation. I'm the host, Lawyer Kofi, and with me is our guest, Lawyer Ernestina Free, who is an employment and HR consultant. And we're talking about employment contract variation. This show is being streamed and broadcast live on Facebook via the Jaqua Radio, as well as the Jaqua Media YouTube page. You can tune into any of these. Obviously, after the program, the videos will still be available if you want to go back and rewatch and understand. If you are tuning into any of the Jaqua Media platforms, then we will ask you to maybe like the page so you get our notifications. If you are listening to us on YouTube as well, then you can subscribe to the Jaqua Media YouTube page and click on the notification bell as well, so you get notified anytime that we're having a program and it's streaming. Okay, all right, so we will continue, and obviously keep your questions coming as well. So you can use the comment section on Facebook and even on YouTube as well, and we'll pick these things up. Or alternatively, you can send it to us on our studio numbers, as some of you have already done. And the numbers are coming on the screen now, but I'll just quickly repeat it for the benefit of our radio listeners. So the numbers that you can send your questions or contributions to us are 07903133842 or 07904862964. Okay, Ernestina, back to you.
Okay, so the one last point that I want to make here is that the doctrine of unfair contract terms does not apply to employment contracts.
We have to unpack this. Too many legal jargons. We have to unpack
it's a consumer right. So the right that this term is not fair is not fair to say you would do this or you will not do this. It's a consumer term. It's when you are buying things where the bargaining powers are equal that the doctrine of unfair contract terms apply. So in employment law, there's nothing like this contract is not fair, to put it in the short sense.
Yeah, so obviously, yes, obviously that's well explained. So for our listeners, just so you know, this law exists purely to protect consumer contracts where there is unequal bargaining powers between the parties, and obviously, this doctrine applies if the term is so one-sided that it's unfair. So obviously, so what you're saying is this doesn't apply at all in employment contract.
Not at all in employment law. Employment law is take it or leave it. It's very
okay. All right, so that's fine. So we can carry on. Keep your questions or your contributions coming, and we'll put it to our guests.
Okay. So the at that point, apart from agreeing or accepting the change, you can also negotiate with your employer. So if you are in a union, or even if you are not in a union and the change is across board, the employees can elect an employee representative, and that person will go into consultation with the employer, try and reason with them, and say, why can't we do this to avoid the change? And then you try and negotiate what will help. You can send a message to your employer or ask for a meeting with the employer to discuss this. If you are objecting to the change, you have to put it in writing, state your grounds, and suggest alternative ways of meeting the employer's needs. So if you don't want the change, why? What is it that you don't like about the change? And this is your chance to state how the change is going to affect you. So back to my 8 hours, 5 hour hour example, if it's going to put a big financial strain on your finances and you've got other commitments, this is your time to tell the employer, if you do this, I'll not be able to pay my rent. I'll not be able to pay this. Is there a way that we can make this work? That is your time. That doesn't mean you've got a right to it, but you can negotiate. And most of the time, it does help. Another way, or what you can do, is to raise a grievance. That is if you've got time. So if your contract doesn't have a variation clause, and let's say you haven't been consulted, they've just written to you and told you, oh, we've changed the contract and it's coming to effect next week, or it's coming to effect in 4 weeks, then that is definitely an issue that you can raise a grievance again. So how do you raise this grievance? You need to check your grievance policy. As I said earlier on, you have a handbook or your contract should tell you how to raise a grievance. If there's anything going on in the workplace that you are not happy about, you can raise a grievance. You need to check if you have enough time for the employer to address the issue that you are raising. You need to know what process the grievance policy is asking you to follow, who you should send your grievance to. And in the grievance letter, you're going to state what the issue is and what outcome you want. So that is the grievance bit. So if you don't accept it, the change, if you don't accept the change, or if you object to the change, and your negotiations fail, and your grievance also doesn't come up with anything, then you go to the last option I said, which is legal remedies. Take legal action. What actions can you take? It depends on your employment status. Are you an employee or are you a worker? So what claims you can bring is, if it's in relation to your wages, you can bring an unauthorized deduction from your wages at the employment tribunal. That will be where you are entitled to a pay rise and you were not given, or a bonus and it was just cancelled towards the end of the year when you were meant to get the bonus. They've just said, well, we're changing the contract, you're not paying any bonus. That is unlawful deduction in your wages. You can sue for damages in the county court for breach of contract. You can also bring a claim for breach of contract at the tribunal as well. You can leave your job and claim constructive unfair dismissal. That is a very tricky one because there are a lot of rules around that, around constructive dismissal. So if you ever consider that, please speak to a lawyer and get the advice before you do that, because you have to resign. The resignation should be a spontaneous response to the action of the employer. You have to be an employee, and there's a lot of things around it. It's not that simple. So please take advice if you're thinking of resigning and claiming constructive dismissal. If you were picked unfairly for that change, then that is definitely discrimination. So you can bring a claim for discrimination as well. So to end I've got to my promotional slide.
Yes, the all important slide.
That is the most important bit of all these slides. So, employment solution consultancy, we are employment law and HR specialists or advisors. We support both employers and employees. So, for employers, we can help you with drafting your contract, handbook, amending them, and all other HR related letters. We can help you with that. We can help with mediation. If you've got disciplinary or grievance, we can chair it and conduct it throughout the process for you. If you are an employee, we provide trade union services. So you join our union, and then when you've got issue at work, you just give us a call. The membership fees are as cheap as £5 a month, £10 and 15 £15. So check it on our website. If you subscribe to the £5 a month one, you give us a call whenever you've got an issue, and we will help you with that. With the £10 one, we will help you over the phone. We will write letters for you, and we will also accompany you to a meeting at the workplace. And with the £15 one, if you need to go to a tribunal, we will do that for you, and then you will get a discount of 50%. So it's very good. It's very important in this climate. I think if there's anything you should think about, it will be protecting your job. Look on our website, employmentsol.co.uk, or contact us on 074 or 078 or contact Jaco Radio and they'll give you our details. Thank you. If you let's do this.
Yes. So thank you very much, Estina, for the wonderful presentation. Obviously, thanks to our listeners and those that have sent questions in. Keep them coming on your comments as well. We'll deal with them now. I think we've got about 3 more minutes to wrap up today. So we're finishing early, but don't go away. There will be another program on the Jaqua Media platform. So there'll be the Jaqua Health Show coming after this program. And today they will be looking at discussion on allergic reactions to vaccines, which is quite topical at the moment with the COVID-19 vaccine coming on stream. So they'll be having a discussion on that. So do tune in at 8:30 for that program. Now, so today we're talking about employment contract variation. Somebody's asking that how often does this happen in practice? Do employers do this quite often?
You mean changing the terms and conditions? A lot.
Yeah.
A lot. And even in recent times, it has been even worse. Between August, September, October, when furlough was going to an end, most employers who did not have layoff clause in their contract amended their contract to put a layoff clause in there so they could lay the employees off when there was no furlough pay. So it depends on the circumstance, but it happens a lot.
I see. Okay, so that is so it looks like it's something that most especially now, obviously, because most employers are trying to deal with the economic situation as well. So it's very important that people are aware about these things. So you did touch on this. This my question to you, just to also help our listeners understand that obviously we've said this so many times on the show that oftentimes the last thing that people look at is their employment contract. When they get a job, they're just excited to have a job. They don't really go and read what the terms of the contract really states. And so these things oftentimes come as a shock to most people because they don't know whether their terms of employment allows these things or not. But you did mention the fact that if there is a variation clause in your employment contract, then your employer has the right to do these things.
Yes.
In the situation where is that standard? Is that we've got all these boilerplate clauses that people put in? Is that a standard thing in almost every contract of employment, or there are some contract of employment you wouldn't have these? And my follow-up question will be, where this variation clause is not in your employment contract, then as an employee, what grounds do you have to actually resist these changes, especially if it affects you adversely?
Okay. Most employment contracts have the variation clause, at least the one that says you might be required to do more.
Yes.
Almost every contract says that we might ask you to do other things that is not part of your duty. So every employment contract has a bit of these clauses, but most of them have many of them. It depends on the type of organization. So if an organization that have multiple sites come to me and ask me to draw up a contract for them or a handbook, I will advise them to put in a location clause. So
Okay.
that if one location is closing, it will be easier for them to move the employees to another location. So it depends on the industry on which of the clauses will be in there. But at least in every contract, there is some variation clause in there, a bit of it somewhere.
Yes. So my first question will be, if there isn't,
Mm-hmm.
obviously, then
How do you challenge it?
yeah, because obviously if there isn't, then employer is not entitled to just vary it without an agreement. So how do you challenge it?
Yes. Yeah, so if there isn't, that's when they need to consult you and tell you why they need to make those changes. And it's up to you whether you accept it or you reject it. And then, so if there isn't any clause in there, you have the right to be consulted and you have to agree to it before. If it's in your contract already, it means you've agreed to it when you sign the contract. So there's no need for consultation or agreement because they already have the agreement.
Yes. Okay. All right. So that's very good information. Obviously, I think so what would be your general advice to people that are going through anything like this? Obviously, if people wants specific advice to their peculiar situation, then you do need to contact as outside the show, and Celestine has a wealth of experience in this area, and they will be able to help you that way. So yeah, but generally, what would be your advice to people when they are faced with this situation? How should they approach it?
Okay. So the first one is, as I said at the beginning, everyone is entitled to a contract of employment now. So make sure you have one. I've got clients that I ask them, how many days holiday do you have in a year? And it's like, I don't know. Do you have a contract of employment? I can't remember. I was given one, I think. Oh, I don't know. Where do I get it from? So if you don't have a contract, contact HR and tell your manager you need a copy of your contract. Everyone needs a copy of your contract. And read what is in the contract. It might be too late to negotiate it because you've already signed it. If you are starting a new job, although there's no bargaining power, it will be important for you to know what is in there and whether you
Yeah.
are happy with that. I've seen some employees who have managed to negotiate what is in their contract. It doesn't happen a lot, but it depends on the type of job you're going to do and how desperate your employer needs you. So it works, not much, but sometimes it does. And if the clause that you are not happy with is not a clause that they use often, they'll be happy to take it out. As long as you're not going to tell the other employees that you've asked them to take this off your contract. So if you are going into a job, look into the contract and see what are they asking you to do. What are they asking you to sign? Make sure you understand it before you sign. It doesn't happen. I don't do it anyway. But if you can do it, it helps a lot. And then if you know what is in your contract, before you take any action in the workplace, refer to your contract. What does my contract say? So if you go to work and your employer tells you you're making these changes, go to your contract and check, do you have a variation clause there? No, then they have to consult you. They have to tell you the business case. Why do they need to make these changes? And then it's up to you to decide whether you will agree to the changes or you will reject it. But please bear in mind that the risk of not agreeing is very high. You could lose your job If you're going to say, well, if I lose my job, I'll take them to the tribunal. Fair enough, you can't take it to the tribunal. But trust me, it takes ages to take a case to the tribunal. Tribunal cases are now being listed in 2022. So if you take your case to the tribunal now, you're going to wait for 2 years before it's heard at the tribunal. So think about it. You've got those rights, but what do you need now to survive in this pandemic? That's what we should think about.
Yeah, that's very important. And obviously, we do tell our listeners all the time, and don't be in a rush to take things to the court. It's not a simple process, as people think. You know, even if you win in the end, the process itself is not a simple one. There's so many implications, cost, you know, the emotional and psychological impact. So you have to take all these things into account before you actually make the decision to pursue a claim. Obviously, in this respect as well, there are some situations that obviously it will be proper to pursue a claim. Before you do that, make sure that you've engaged the services of a qualified person to advise you on any possible merits you may have.
Yeah, Kofi, and can I say something?
Yeah, sure.
There's something in employment tribunal called Pockley deduction.
Yes.
It's from a case called Pockley. And what that means is you might win the case 100%, but the judge will say you are at fault. It's because of you that this case came here. And because of that, you will not get anything. So you might win the case and not get any compensation.
Yeah. So yeah, you have to mitigate, and obviously you have to mitigate your loss as well. But I mean, the courts are always trying to ensure that people find means to resolve issues before it comes to the court, and all these measures are there to ensure that people actually engage constructively to resolve differences. And employment law is a hot cake right now. Because of the COVID situation, there's all kinds of things going on, redundancy. Oh, actually, yeah, that's the question that I wanted to ask, which I forgot. How is in terms of, so how does it, you did mention the fact that if your employment contract is terminated, and in fact you did mention that you have advised employers to terminate and issue new contracts for the terms that they want to provide if it's being resisted. So in terms of that, obviously you've also mentioned some of the remedies that may be available to an employee. I always come back in terms of not unfair dismissal, but the other one, wrongful dismissal or breach of contract claims. So for employment law purposes, obviously, clearly there might be a breach because, you know, but in terms of the compensation that you get, is it really a worthwhile course of action to take when it comes to breach of contract, not unfair dismissal, but breach of contract for wrongful dismissal?
Kofi, it depends on how much you get paid. Because the wrongful dismissal is usually where you haven't been given notice. So let's say you are due 3 months notice and you were not given any notice. So if you win, what they're going to give you is the 3 months notice that you were due. That is all they will get. You will get in compensation.
Yeah. So I think it's good that people need to be aware of this. Obviously, if you're pursuing a claim for wrongful dismissal, oftentimes what you're going to get is your notice period. And if your notice period is a week, that's what you get. If it's a month, that's what you get. So always think about that before you do, because obviously if it's not worth losing your job over that, then you may want to pursue some of the other options that have been mentioned, like negotiate or even accept. It may not be what you want, but just accept. As long as your statutory rights have been protected, I think then it may be an option to pursue. But like I said, whatever your circumstance or your situation is, if you need tailored advice, do get in touch. And Xtina is an expert in this field and she'll be able to assist you also with the employment agency as well. Now, the amount of times that I do come across people that have employment situation at work and then they don't belong to a union or anything like that, it gets very difficult to deal with and even more expensive. But if you have a union representation, if you have an agency like an students agency supporting your employment rights, then you will be in a better position to deal with most of these employment issues. Having said that, I do have a referral for you, so let's speak after the show. On
Okay.
this note, I think there isn't any question. If you do have any question, do send it to our time is up. So we're just wrapping up the show for today. But if you have any question on what has been discussed today, or if you do have generally employment law um, questions, then do get in touch with us after the show, and we'll put you in touch with the right people to assist you. This is a Mmra show we brought to you every Sunday. Even having said that, we've not been on air for quite some time now. But yeah, every Sunday, if we are streaming, then it will be Sunday evening, 7 p.m. That's when we come live on this program. I'm your host, Lawyer Kofi Ejo, and today it's been a privilege to have our guest, Lawyer Ernestine Freer, who is taking us through this all-important topic. And thank you for listening. Do go to the Jokwa Media YouTube page to subscribe to that page as well, and you will get a notification anytime we're streaming, and also all the information that we're broadcasting. There will be videos there for you to go and watch and rewatch and share with your family and friends as well. On this note, I say thank you, a big thank you to my guest for today, and thank you to our listeners as well for tuning in.